We'll call Officer Raymond.
Good morning. Raise your right hand. Swear or affirm, tell the truth, the whole truth, nothing but the truth today. Watch your step on my ramp. Have a seat. When you're ready, Counsel.
Thank you. State your name, please.
Officer Chris Rain, Brown Police Department.
Officer Rain, good to see you. Officer Rain, how many years have you worked for the Romulus Police Department?
Be 10 years in July.
Taking you back to December 19 of last year, 2025, about 4 in the afternoon, were you working?
I was.
What were you doing at that time?
I was on patrol.
Did you have a partner or were you acting alone?
I had a partner, Officer Myson.
Are you in a marked vehicle or unmarked?
Mark,
Uniform or no uniform?
full class vehicle.
Did you have contact with a woman named Cassandra Eric?
I did.
Eric.
Yes.
Where did you have contact with Cassandra Eric?
In Ron, City of Romulus?
In what municipalities are located? You said Romulus.
Correct.
Officer, what caused you to notice this person, Cassandra Eric?
The rear window of her vehicle was completely blocked, as if she wouldn't have been able to see out of it,
Is it a ticketable offense?
as far as I understand.
Do you remember where precisely you first encountered the driver of the other vehicle?
It was in the area of Inkster and Wick, is what I recall.
Now, as a result of noticing obstructed window, obstructed windshield, windows, what actions, if any, did you take?
I conducted a traffic stop.
Do you remember what type of vehicle this person was in?
I remember being a smaller sedan. I don't remember the specific make and model, unfortunately.
Do you know whether the driver was alone in the vehicle? Now, if you saw the driver of that vehicle again, do you think you recognize it?
I would.
Look around the court and let Judge Oakley know whether you see it.
The young lady in black.
Your Honor, may the record reflect the witnesses identifying the defendant.
Noted.
When you made a traffic stop or initiated a traffic stop,
Right.
did the driver decide to comply?
She did. I made contact with the driver's side of the vehicle and we discovered that her license was suspended.
What did you do when you learned the young lady's license had been suspended?
So with our policy and procedure, it's an arrestable offense. I got her out of the vehicle, placed her in handcuffs, and walked her to the back of the patrol vehicle after conducting a search on her person.
Did you conduct a search of her person?
I'll be honest, the person, I don't remember if it was myself or my partner, Officer Mahison. I know I searched the vehicle, but I can't recall at that moment if I searched her person or if he did. One of us would have conducted a search.
Any contraband found?
Not on her person.
Did you find any contraband?
I did.
Where did you locate contraband?
It was inside of a purse, which had a couple plastic baggies in it. It was on the passenger side of the vehicle.
Any other women in the car or standing in the car?
No, sir.
Officer, what happens when you confiscate what might be controlled substances?
We collect it, we hold it with us until we take it to the station. We kind of do what we call processing the evidence. So we secure it, generally a manila envelope or a plastic baggie, secure it with property tape, put it in a drop box with what's called an MSP lab sheet, which is just us asking the Michigan State Police to do an analysis of what we believe is narcotics. And then
Defendant never stated to you that she had a valid prescription for the controlled substance?
not that I recall.
So what happens ultimately to this defendant?
She'll be arrested for possession of narcotics.
Hey, Greg, nothing from you.
Cross, Ms. Ridgway.
Officer Reyna, you were driving, right?
Yes, ma'am.
So you're the one who pulled over your scout cars.
That's right.
And you did that because of the allegedly obstructed rear window of this Ford Focus.
Right.
You didn't really notice anything else about this car, right?
Right.
It had all its mirrors
As far as I know, yes, ma'am.
and it was operating fine.
Yes.
I have no further questions.
Your Honor, people arrested.
Any defense witnesses?
No,
Ready for argument.
Any case happens thousands of times across the United States per day, maybe not Saturday and Sunday. You have police officers on patrol in a marked vehicle, Judge. They observe a car with obstructed view for the driver. They initiate a traffic stop. In doing so, they learn that the defendant has a suspended license. And as you know, Judge, that's an arrestable offense. They arrested her. They search her, incident to the arrest. And it's unclear as to who did what. Collectively, the two of them confiscated the drugs, and you know that they followed procedure. You've heard from both of them as to what happened to the controlled substance. We would seek a bind over as charged.
Counsel.
Your Honor, this case was a violation of Miss Irick's Fourth Amendment rights, and she was pulled over for this alleged infraction. MCL 257.709 clearly states that a person shall not drive a motor vehicle if driver visibility through the rear window is obstructed unless the vehicle is equipped with 2 mirrors, 1 on each side. So the only way that they could have probable cause to pull over Miss Irick on this day is if her back vehicle was obstructed and she was missing 1 of her 2 side mirrors. We just heard Officer Brand say nothing else was wrong with the vehicle. There was no probable cause to stop the car. That is from Brennan versus the United States. That is established law. There was no probable cause to believe a traffic violation had occurred.
Mr. Kaplan, argument?
Justification heard unequivocal testimony that that vehicle, the silver Ford Focus, 2012, had an obstructed rear window. That's dangerous. It's dangerous driving that way. It could lead to accidents. Legislature doesn't want that. In this case, that's what she had. It's a question of fact for the jury beyond.
Essentially, the police have to follow the law. They both testify that they're police officers, that they know the law. They pulled Miss Irick over outside of their bounds as law enforcement. Okay, I understand seeing something obstructed and thinking, oh, maybe she can't see, but unless you have probable cause to pull somebody over for a traffic infraction, you cannot do that. And from this infraction, Miss Irick was arrested, a search was conducted. That is all fruit of the poisonous tree in this case. Thank you.
How is it probable cause if it's not a infraction?
Obstructed window, obstructed rear window is an offense, and it's dangerous.
But she just read me the statute. And it said that the obstructed window is only an infraction if she doesn't have side mirrors.
You have to bear any evidence about it.
I did. She asked him if he noticed anything else about the car. Did it have its mirrors? And he said, as far as I know.
We take the position that had he not stopped that vehicle, could have been a very serious accident.
Could have been. But I drive an F-150 with a cap on the back and I can't see spit out of my window other than headlights at night. Dismissed. Good police work doesn't always end up with convictions.
Hey,
Boy, you don't get many of those like you just had. That just straight up. Yeah, but I mean, you just don't get too many of those. Just that straight up bad. I mean, they thought they had a good reason.
No, she did the research on that.
No, as soon as he started saying the reason for the stop, I'm like, wait a minute, I can't see out of my back window unless there's headlights behind me.
Yeah.
All right, appearances for People versus Littleton.
Morning, Your Honor. Elizabeth Moore on behalf of the people, P847240.
Good morning, Your Honor. Attorney Sahar Cross and Attorney Martin James Case, hearing on behalf of Mr. Littleton. Mr. Littleton, can you please introduce your
All right, ladies, we ready to go?
Yes, Judge, the people are ready to go, and I have a complaining witness who flew in from out of the country to be here today.
All right, put her on the stand.
Your Honor, I mean, Mr. Littleton, to refer the competency at this time, the defense counsel is adamant that Mr. Littleton is no way understanding the nature or the object of the proceeding and cannot. But he is not fully aware, Your Honor, when I try to ask him, or explain to him that I'm his attorney. He doesn't.
Let me stop you. When did you talk to him and realize you had those problems?
Well, it's been a compounded conversation. So it was the first one that it was a little off. If Your Honor was, I'm not sure if Your Honor was the judge at that time.
Was not.
Saying that I didn't think anything.
Counsel, my question was a simple one. When did you know you had this problem?
So I'm telling you, it's a compounded issue, Your Honor. It wasn't just the first time, it was the second time also.
Denied. Denied. Twice I've asked you a direct question, you can't answer it. No, I asked you for a date. When did you know you had the problem? They flew somebody in from out of the country. If this was a problem you could have told them about a week ago, we could have avoided that. So we'll go ahead with the exam. You can do whatever you want. You can build whatever your record is. We're going to use the witnesses that are here today.
This one is
I didn't ask for an argument, counsel. I just told you my decision.
going to be completely, I think we should be ready and what can be administered. Mr. Wilson, I have no opportunity to review the discovery. I'm not the attorney of record.
Then why are you here? Who's the attorney of record?
And that is correct, Judge, as much as Ms.
So schedule a show cause for Attorney King for contempt of court. Would somebody like to explain to me why the attorney of record is not here for a scheduled exam?
Understanding when it's a different environment that he's explaining to us because I was going to come here anyway, and because Mr. Littleton was going to refer to competence.
No, he wasn't. No, he wasn't. You were going to ask for that.
The court, the statute requires that the court at least consider the referral to competency at this point in time juncture. I understand that there has been a delay in the complaints from out of the country. However, the statute is very clear. And if Mr. Littleton cannot assist rationally, cannot comprehend what is actually happening, actually he cannot move forward. And I think the court has an obligation to consider what.
Here's what I consider. Here's what I consider. Your office is continuing to do this to the court docket with attorneys that are scheduled, that don't show, don't call, just ghost us. We've got attorneys that show up the day of the exam having never spoken to their defendant repeatedly, day in, day out. Every Wednesday we have the same thing. Your office is disrespecting the Wayne County bench. Is that clear? We've been told we have to actually hold you people in contempt so that they can withhold the payment for the job that you're not doing. Would you like to say anything?
Judge, I just asked for an opportunity to make a fair record, if I may.
Go ahead.
So first of all, I would like to note that this is my first time actually working with Ms. Barrage. This is not, I believe, her choice. I believe she was sent here by Mr. King.
Oh, it sounds like they threw her to the wolves.
I just want to acknowledge that. I don't think that this is a problem for me.
No, she's just lucky enough to be the one I yell at. No.
Judge, I contacted Mr. King. I called NDS last week, contacted them specifically so that I could figure out ahead of the PCC who the defense attorney was. I found out that it was Mr. King. I contacted Mr. King. I got a hold of him that day. It was the day before the probable cause conference. I let him know that I was personally sending him the digital discovery so that he could review it. I indicated that there may be some competency concerns, and I asked if he would let me know if he would be referring for competency. I also let him know that I spoke to the out of the country complaining witness, confirmed the next 4 to 6 Wednesdays her free in her schedule, and let him know that we would be flying her in, and told Mr. King that I would make any of those days work, but that if we scheduled an exam for her to be flown into the country, and Judge, this is very important, this happened at the airport, so flown into the airport that she was sexually assaulted in, that if that happened and if she came here, we were holding this exam. Because I was not going to have the victim come all the way back here, only to be told that there was an adjournment request or have him be referred for competency. I asked Mr. King that. I did feel at the time like he was dismissing me, but I also recognized it was pre-PCC. The PCC happened. I appeared early. I was not present when the actual date was set. It was set for 7 days out. We did everything that we could to get the victim here. I had the officer in charge meet her where her plane landed at the actual gate to get her from the gate through the airport. Again, she was sexually assaulted into her hotel to keep her calm because she's been extremely traumatized as a result of this. Prior to this, after all the arrangements were made, I started calling Mr. King 48 hours before the victim needed to leave to come here, just to confirm that he was not planning on asking for an adjournment for discovery, to confirm that he was not planning on referring the defendant for competency. He refused to call me back, refused to answer my text. I got a call from him this morning at 8:30. It was the first time he has spoken to me since pre-PCC last week. And that is when he told me that he had not spoken to his client, that other members of his team had fortunately stepped in to speak to his client for him, and that they were concerned about his competency, and that he wasn't sure if the defendant would be able to sit through with this hearing today.
This is totally unconscionable.
Which I told Mr. King that we would address the, because to be fair, Judge,
Mr. King better bring a toothbrush when he comes for the show cause. Please send that message. Clear? Counsel? Clear? Answer my question. Clear? Make sure he brings a toothbrush when he comes for his show cause. Thank you.
if I may, Judge, I recognize I have no actual power to object to a competency referral. And I recognize that. But the way that this was handled, it is one thing to inconvenience me, and I have a lot of respect for the neighborhood defender services. There are several of them here at this courthouse that I have so much respect for.
Me too.
But how this was handled was completely inappropriate, and I told Mr. King that, until there was an actual issue in court, we were here, we were ready to go, and I'm at a loss, Judge, because ethically as a prosecutor, I know that I cannot push to proceed when there is a genuine referral for competency. I don't want to compromise my ethics, but this is extremely difficult for the position that we are in, and the reason we're in this position is because of Mr. King.
If I may, Your Honor.
Go ahead.
Well, thank you, prosecutor, for the procedural history, and I can't speak to the conversations of the prosecutor had with Mr. King directly. However, I will remind, or just say, that at the times and moments that Mr. King was stating that he did not intend to refer to competency until after buying over, that those were true statements, and it wasn't until understanding the actual, and not to get into privileged communications and client confidential conversations that we've had, that even at this preliminary examination, even if it is probable cause, and even though he's told the prosecutor that we don't intend to refer to competency until later, it was clear that Mr. Littleton has an issue understanding the order, nature, and proceedings, as well as not being able to assist rationally in his defense. So it's not to say that Mr. King wasn't being honest or truthful, but
He was being lazy and unprofessional, counsel. He never spoke to the defendant.
Your Honor,
Unless she's lying to me, King told her he'd never met with Mr. Littleton. Other people from his office had.
I wasn't part of that conversation. I can't speak to them. I'm not
Then I'm going to take her at her word.
lying. I'm just saying that all the other times that she was speaking with Mr. King and he made the applications and the intention of holding this exam, that was his intention. It wasn't to be dismissive. He wasn't refusing to communicate, that he was figuring out.
Counsel, stop, or I'll hold you in contempt.
Just trying to make my argument.
Keep talking, I'll hold you in contempt. I'm not going to let you make your argument because you don't know what you're talking about. You're not talking from firsthand knowledge. She is. Sit down. Counsel, don't test me.
I'm sorry.
Sit down. You're done speaking today.
Done speaking today?
Yes, ma'am. Who flew in?
Judge, the complaining witness in this case, her name is Nora Al-Thamna, that's spelled N-O-U-R-A, last name A-L dash.
All right, I'm going to want her in here in just a minute. Do the paperwork so we can send Mr. Littleton for his competency, which will be 6 months down the road before we hear anything. You guys can take Mr. Littleton back into lockup. Bring your complainant in. Just podium, yeah. Right here, ma'am. Right here.
Yeah.
Did you tell her what happened?
I did not. I told her that there was an issue and he wanted to see her and that I would explain after this.
So we're not going to have an exam today. I wanted to apologize to you personally for making you show up and put you through this and have nothing of substance happen. I also want to know exactly, with documentation to counsel, what it costs you to show up here today. Because if I find the attorney in contempt, I'm going to charge him for your costs. You understand that? All right. I just wanted you to hear it from me personally that I apologize on behalf of the system. I apologize to you because the system is not treating you well. Thank you, counsel. Ms. Moore, anything else?
Thank you. And again, I just want to acknowledge that I do not believe that Ms. Farage did anything. She was just sent.
I don't disagree.